Hello, and welcome to another episode of Immigration Talk with the Molina Firm. My name is Gianna. I'm a lead attorney here in the Dallas-Fort Worth area. We do offer services worldwide, so if you do need assistance, feel free to leave a comment below or contact us directly, and somebody will gladly help you. Today's topic, we are going to discuss 3 common questions that we get as immigration attorneys. Let's begin. Number 1, what is the difference between consular processing and adjustment of status? This is a very common question. Lots of people don't really understand the difference, so let's get into that. Consular processing and adjustment of status are 2 different ways of obtaining your lawful permanent residence. So consular processing is usually for individuals who are outside of the United States who are trying to come into the United States. So the first thing is that the people outside the United States, they apply for an immigrant visa at a U.S. consulate or an embassy. There is an interview that they do. Once that interview is done, if everything goes well, your visa gets approved, you are able to enter as a lawful permanent resident. This is also something that people who are inside the United States have to do if they have 180 days or more of unlawful presence. So in this situation, the people in the United States would need to apply for a waiver. And then if that waiver is approved, then they go to their home country, do the interview, the whole process there, and then they come back in as a lawful permanent resident. So that is consular processing. Adjustment of status, you can do it here in the United States. It's usually for people who are already here. These individuals entered lawfully or through parole. There is a visa immediately available for them, and that person is not inadmissible. So those are the differences with consular processing and adjustment of status. Number 2, what to do if you are facing a removal proceedings. That's another common question. So I understand that this is a very scary situation to be in. The first thing that you must do is act promptly and consult an immigration attorney as soon as possible so that they can help you understand your rights and explore any potential defenses for you. You must attend all of your hearings, and you should gather all documents, all evidence that can help support your case, such as proof of your residency, any family ties, and any other evidence that could qualify you for relief of removal. You also need to stay informed of your cases, comply with all your court orders, and just discuss more in depth with your attorney to help you find any type of relief from deportation. And lastly, number 3 is, how does one become a naturalized citizen? So this is a very common question that we get as well. So it is a process that a person has to be at least 18 years old. You have to be a lawful permanent resident for, usually it's 5 years, but if you're married to a U.S. citizen and you adjust status through that U.S. citizen spouse, then it's 3 years that you have to wait. You also have to demonstrate continuous residence and physical presence in the United States, which means that you haven't left the United States for more than 6 months without showing good cause for that departure. And you also have to be of good moral character. So the whole process, once you submit your application, you get an interview, you attend that interview. If everything goes well at that interview, then you get a decision, and then you get approval. And then once you get approved, then you get to attend what's called the Oath of Allegiance ceremony, where you take that oath, and that's pretty much the last step for you to get your naturalization certificate. And then you are officially a United States citizen. That is all I have for you today. As always, if you like this content, give us a like and share with your friends, and feel free to leave a comment below. And I will see you guys next time. Bye.